Welcome, welcome everybody. My name is Aurélien Lorange. Together with my colleague Anna Maria Urbanova from the Corax Foundation, will organize today the first match of this group between two universities who are starting the Inter-University Law Debate Tournament 2024, 7th edition. We have two universities competing today. They received a debate topic 7 days ago. They prepared, they don't know yet which position they will get, we'll know today, just before the match. So this is the University of Manchester, United Kingdom, and the University of South Pacific in Fiji, in Suva. We have here both teams, as you can see. We as well send greetings to the judge who will be watching this match during the next 48 hours or 2 working days. Just for your information, the three judges do not know each other. They will assess the match independently. We can tell you that the three of them are currently in Europe. But yes, they have never worked or got any connection with your universities. So now we'll introduce the main actors of this match. It means the students themselves. I will ask alternatively each student to introduce themselves. Starting with Miss Fatimatou Zahra Diallo in Manchester. Welcome.
Thank you. Hi everyone, my name is Zara and I'm representing the University of Manchester today, and it is my pleasure to be here with all of you.
Thank you very much. Welcome. We have as well in the University of the South Pacific, Varunesh Vikash Permal. Welcome.
Hello everyone, it's wonderful to be here. My name is Varunesh and I'm representing the University of the South Pacific. Thank you.
Thank you very much and welcome. We have as well in Manchester Mr. Abdullah Atassi. Welcome.
Hello, my name is Abdullah Atassi and it's a pleasure to be here to represent the University of Manchester.
Thank you and welcome. In the University of the South Pacific we have as well Visha Vishalni Prakash. Microphone. Microphone. Yep.
My sincerest apologies. Greetings, everyone. My name is Visha Vishani Prakash, and I will be representing University of the South Pacific, and hopefully have a great learning experience with y'all. Thank you.
Thank you very much, and welcome. We have as well, as a third member of the team of the University of Manchester, Mr. Adalberto Dionisi. Welcome.
Thank you. Hi, everyone. It's a pleasure to be here. I'm Adalberto Dionisi. I'm representing the University of Manchester. Thank you.
Thank you and welcome. And third member of the University of the South Pacific, Kaya Nagma Lal.
Nisambula Vinaka, everyone. My name is Kaya, and I'm a third-year student with USP. I'm very excited to be here today, and good luck, everyone.
Thank you very much. Welcome, and Bula, as we say. And I just want to mention as well that you have as well two coaches which are not in the room. I mean, the University of the South Pacific, Professor Samanunu Vaniki and Peter Pranesh. So as mentioned, you received a topic 7 days ago. This topic was connected to the general theme of this competition, of course, is the first one of the first match for your group. So that will be national autonomy is essential. International human rights norms should respect diverse cultural context in conflicts. So now we'll know which position you will have for the match. My colleague will share the screen. So as you can see, there is a wheel, and we'll know there are two positions possible, in favor and against for each university. So my colleague will click on the wheel, and we'll know the result live, which position you will have. So this is University of Manchester will defend the position against. It means that the University of the South Pacific will defend the position in favor and will be starting the match as well with an introduction. Concretely, it means that, to clarify, the University of the South Pacific will defend the position that national autonomy is essential. International human rights norms should respect diverse cultural context in conflict. On the other side, the University of Manchester will defend the position that national autonomy is not essential. International human rights norms should not respect diverse cultural contexts in conflicts. So now you will have 5 minutes for reviewing your notes. In those 5 minutes you can close camera and audio, and we'll start the match with the introduction by the University of the South Pacific. See you in 5 minutes. Okay, so we start the match. So we'll hear the introduction by the team of the University of the South Pacific. So I give the floor to the student who will be starting on the side of the University of the South Pacific. You have 4 minutes.
Thank you. Your timer will start once you start speaking. Just a reminder also for the audience, yellow cord signifies 30 seconds left of the speaking time. Red cord signifies the speaking time is over. Best of luck, starting at the University of South Pacific.
Before the timer starts, may I confirm that I'm audible and visible, please?
Yes, you are.
Thank you. Greetings to the honorable judges, colleagues, and audience members. Today, we will affirm that national autonomy is essential and international human rights norms should respect diverse cultural contexts and conflicts. We will advocate for our stance through the following arguments. First, there needs to be proper acknowledgement and respect for cultural contexts. Second is recognizing that culture is always evolving. Finally, respecting cultural and national identity. Cultures and customs form an integral part of communities, shaping their ways of life, identity, and norms. They reflect the practices of different groups and make us diverse and distinctive. Given its significance in national identity, many nations and organizations attempt to protect these values through codification. For instance, South Pacific nations like Vanuatu and PNG recognize the appreciation of traditional ways and culture in the Constitution's preamble. Kenya's constitution recognizes culture as the foundation of the nation. On an international scale, the 2007 Freiburg Declaration considers respect for diversity and cultural rights as a crucial factor and calls for the clarification of the position of cultural rights within the human rights system. While there is recognition that cultural contexts need to be respected and considered, there is an opposition between cultures and international human rights. This is due to the perception that cultural practices infringe on individual rights provided by human rights laws. Our stance is by no means an attempt to undermine the value of international human rights. We recognize major strides that international human rights offer. However, it is important to recognize that diverse backgrounds, lifestyles, and identities exist, and that a one-size-fits-all approach does not apply. There needs to be cultural sensitivity and acknowledgement of cultural diversity. This is imperative since culture can positively influence the way conflicts are resolved. Shifting the focus onto conflict resolution as opposed to debating over the rightness of universality is an important prioritization as it aims to look for a solution that suits both parties. Second is recognizing that culture is evolving. As culture and international laws continue to evolve, we argue that nations need time to acclimate to these changes. This is not a new concept, since case laws demonstrate that customs can be in line with international standards. However, they must be introduced into communities through custom, not imposed by international human rights. In South Africa's constitutional case of Ngwenyama, the custom of polygamy was modified in a way that husbands would be required to get permission from their first wife before engaging in polygamy. This step was a way in which the gender inequality gap was considered in South Africa while acknowledging the customary practice. Another example is the evolution of the customary apology of Mbulumbulu in Fiji. Here, conflict resolution was conducted by offering a traditional gift. Initially, this was used as a mitigating factor in rape and domestic violence cases. However, through awareness, women's movement, and time, courts in Fiji have deviated from this tradition and rarely use it as a mitigating factor. This shows that culture is evolving and that international standards can be adopted. Additionally, it ensures that changes are brought in a more organic and digestible manner in accordance with the people actually involved in the situation. Finally, respecting cultural identity highlights the importance of national autonomy and reiterates that cultures are unique and deserve respect because they govern and shape the lived realities of very real humans. Cultural customs have throughout history demonstrated an innate ability to adopt, adapt, and adjust to the changing society around them. This is where the strength lies. Turning a blind eye to them would be regrettably deficient and ill-advised. Thank you.
Thank you very much. Now we'll hear the introduction given by the team of the University of Manchester. You have 4 minutes.
Okay, am I audible?
Yes, you are.
Sure.
Dear esteemed judges and colleagues, it is an honor for me and my teammates to be here on behalf of the opposition. We will be arguing against the motion that national autonomy is essential and that international human rights norms shall respect diverse cultures in conflicts. The following will be argued upon 3 key premises. Firstly, I will address the nature of international human rights and the concept of positive obligation that is intrinsically linked to it. Secondly, my colleague Fatima will address the voluntary nature of engaging with international commitments to uphold international human rights, and subsequently the binding nature of entering into such commitments. Finally, Alberto will address the inalienable nature of human rights norms and how conflict is irrelevant to whether they should be upheld. I would first like to contextualize this motion by defining a few concepts. Firstly, what do we mean by international human rights norms? We are defining this as the universally and normally acceptable inalienable rights, such as the prohibition of arbitrarily depriving life, torture, cruel or degrading treatment or punishment, slavery, and forced labor. These are fundamental rights that the international community considers to be normal standards everywhere, aka norms. It is important to highlight that during times of conflict, that international human rights laws are most likely to be breached. In Resolution 2171, the Security Council acknowledged serious human rights abuses are not only a consequence of conflict, but can be an early indication as to the descent into conflicts. It follows that there is an obligation to protect international human rights, as it is most pertinently during conflict, and that conflict is often the time that states don't prioritize protecting these rights, and therefore there becomes an obligation for there to be intervention and for national autonomy to take a step back. This brings us onto the nature of human rights treaties and norms and the positive obligation of states to intervene. This is because by the very nature of such agreements, in order for there to be accountability, in order for us to operate under structures where there is international agreement, there must be a positive obligation for states to intervene when they see breaches of these rights. Otherwise, each state would not involve themselves and would not go to protect other rights at the risk of further inciting conflict. Therefore, this places the importance of intervention above national autonomy for the sake of these norms having any importance. Under the additional protocols of the Geneva Convention exists the obligation to ensure respect with the external dimension relating to ensuring respect for the conventions by others that are party to a conflict. It is stated that accordingly, states, whether neutral, allied, or enemies, must do everything reasonably in their power to ensure respect for the conventions by others that are party to the conflict. Positive obligation means that we must supersede the concepts of national autonomy and act in a way that means we actively intervene in order for states to ensure the upholding of these concepts, whether within their own rights or other states. In order for this to work, these international human rights norms must take precedence over national autonomy. This is particularly important during times of conflict, and really the crux of the argument falls upon conflicts because that is not when we are disputing what should be rights and what shouldn't be. This is when we are talking about when there is a clear breach of these norms, which have often been accepted for time beforehand, as Fatima will talk about. Without a concept of positive obligation, there would be no leverage for nations to abide by these laws. The concept of international human rights works due to a system of accountability. Thank you.
Thank you very much for your submission. We are now entering the rebuttals, starting with the University of South Pacific's debate team. You have 2 minutes.
Thank you. Am I audible enough?
Yes, you are.
Firstly, thank you for the opposing team for your arguments. I noticed that while you began the argument, you began to define human rights norms. However, this is another crucial element we need to recognize in regards to the topic, which is respect. When we mean that international human rights norms should respect diverse cultural conflicts, it it is a very layered discussion. That in the sense that sometimes conflicts in cultures, these are not always indicative of all cultural practices. And that using the extremes of cultures and conflicts in the cultures can make it sound like that our culture, and to give the worst examples of cultures, does not appreciate the time. Let me explain. To give the worst examples of conflicts in cultural context, does not appreciate the time involved and the concerted efforts and great inroads made by diverse cultures in other nations. I do recognize that there are some issues in cultures where we do need to understand. However, these will need to require integrity, genuine cooperation, and careful managing of expectations to ensure the evolution occurs in a sustainable manner. I would like to reiterate that respecting of diverse cultural contexts does not mean staying silent or condoning human rights injustices, but rather ascertaining effective ways to address conflicts in a cultural context and promote fulfillment of the individual. Also, you mentioned a system of accountability, and states have an obligation to maintain that accountability. However, cultures, they are very nuanced, and the systems within these tribes and traditions operate in a different manner. And sometimes state interventions might actually intrude on that, and actually what it can do is do more harm than good. Thank you.
Thank you for your submission. For the first rebuttal of the University of Manchester for the against position, you have 2 minutes.
I'd like to thank my colleague for that very insightful speech. You mentioned that respecting state intervention in certain states does not respect the diverse cultural context within that state. However, and as Resolution 688 of the United Nations stipulates, is that when conflict extends beyond the borders of a state, it is the duty of the international community to intervene in such a manner that the national sovereignty of the other state is respected. For example, for the case of Iraq, when Iraq invaded Kuwait, the United Nations held that such intervention was illegal and that the international community had a duty to intervene. I will now move on to my argument, which is that states have the free will to enter into these international treaties. The international human rights norms, which are enshrined in them, are binding upon states. This is as a result of their inalienable nature and as a result of them being protected in customary international law. In 1991, France reiterated the very known principle that the minimum standard a state has to abide by in order to fulfill its commitments under international law is to protect human rights for their population. But what this also entails is that where a state fails to do this, it is the duty of the international community to intervene in such a manner. For example, in Somalia in the 1990s, UN Security Council Resolution 794 mandated the use of all means necessary to end human tragedy within Somalia. Second, the responsibility to protect has been developed and has been accepted as customary international law. In 2005, at the World Summit, the member states unanimously agreed that where a state was fundamentally violating the rights of its population, it was the duty of the international community through the UN to intervene. Thank you very much.
Thank you very much. For the second rebuttal in favor of the debate statement, the University of South Pacific's debate team, you have 2 minutes.
Hello, can you hear me?
Yes.
Thank you. Okay. Thank you for opposition for arguing on the fact that international human rights norms, its prevalence. However, one must consider that when you're going to impose such values to those countries' state, whereby they extremely hold their cultural context, cultural diversity so closely, do you think that they will want to agree to follow up with it? No, that's not the case. They can't be, because they will find it foreign. which is why it is crucial to understand the true solution of the conflict itself, which is understanding the nuances and the dynamics of the custom and culture itself. Because if you think about it, where did conflict come in the first place? Where did it emerge? It's because of the differences. And this is where culture comes in place. Because cultures, these are norms, belief, way of living that differentiates the perception of one person to another. Therefore, it's important to understand and really eventuate and evidently accept the fact that cultural sensitivity should be paramount in such circumstances. Because if we're able to understand the sensitivities, we're able to minimize miscommunication, decrease the excavation of conflicts, and reach a common ground to reach a mutually acceptable solution. Because we are still in the state, in the global, where we have a lot of issues going on. Child labor, rape, genocide, it's happening. But what is the true root solution to it? Is to understand the culture in its nuances, as evidently respectively known in the 2005 Covenant on the Protection and Promotion of Diversity Cultural Expression, whereby explains that in order to achieve true solution, we have to understand the dialogue of the culture and its expression, its diversity, so that we are able to understand the root of it. We have identified the problem, but what about its true conflict resolution to it? Thank you.
Thank you very much for your submission. For the position against the debate statement, University of Manchester debate team, you have 2 minutes.
Can I confirm I'm audible?
Yes, you are.
Perfect. So I first want to state that the argument outlined by my colleague forgets that there are certain core human rights which must be upheld regardless of place and cultural sensitivity. Because in order to be a human rights standard, that human right must be able to be applied everywhere. And going on to that, I will argue that there are certain core human rights, and specifically the human right to freedom from torture and inhuman and degrading treatment, which must be upheld to the same extent in peace conditions and during wartime, regardless of where the violation is committed. The absolute ban on torture, which must be noted that was born as a concern for the mistreatment of prisoners of war, first in Article 17 of the Labor Code, exists not only in international human rights law, but also in international humanitarian law, and as such is enforceable during armed conflict. In fact, it's prohibited both by the Convention Against Torture and by humanitarian law treaties, such as the Four Geneva Conventions, also by the Rome Statute. And as was recognized in the Ferungia case by the International Criminal Tribunal for the former Yugoslavia, the provision of torture is valid also during conflict. The provision is also recognized as a use contents of customary international law, as was noted by the ICJ in questions relating to the obligations to prosecute or extradite. This is because there is widespread international practice and opinion jurists, as the provision has been introduced in the domestic laws of almost all the states, and its violations are denounced within national and international fora. To conclude, the provision of torture does not admit for any exceptional cultural sensibility. There can be no derogation under the state of war, as in Article 4 of the ICCPR, and it cannot be justified by the need to combat terrorism as the Committee Against Torture found in its recommendations to Israel in 2001. Thank you.
Thank you very much. This now concludes the rebuttals, and we are starting with the conclusions. Starting with the University of South Pacific's debate team, you have 2 minutes.
Ladies and gentlemen, thank you for your attention. As my team had affirmatively argued why international human rights norms should respect cultural diversity in terms of conflict is because, firstly, it supports the acknowledgement that cultural identities and its contexts. Second, how diverse cultural conflicts allow the liberty to evolve sustainably with socially acceptable norms. And third, how the above shape a nation's identity and sovereignty. As the first speaker mentioned, how culture is always evolving, it is largely influenced by political, social, environmental, and economic factors. For example, the cultural practice of bulumbulu that was mentioned was used as a tool by a significant number of perpetrators to seek forgiveness in gender-based violence cases. In other words, the committal of a serious crime meant impunity of the perpetrator in the past. However, such norms has gradually declined, signifying a change in norms. While it is easy for the opposition to give examples of the worst and most extreme kinds in cultural context, giving the worst of things frankly does nothing to address real problems. Yes, cultural practices and conflicts are at times discriminatory and illegal, yet they still persist. Why? It is because they are deeply entrenched in the cultural system. So what is the solution? The real solution is that systemic changes in people's mindsets and attitudes through policies, laws, and practices take time. These need to be done organically and sustainably within society to bring about changes that is transformative and sustainable, which people can maintain. However, respecting diverse cultural context does not mean we are against human rights norms, but rather finding ways to address cultural conflicts that is sensitive to cultural identities and the rights of individuals. This is the view of the affirmative team. Thank you for listening.
Thank you for your submission. With the debate team of University of Manchester, you have 2 minutes for your conclusion.
Thank you. I'd like to just address a bit of rebuttal to start with. Fundamentally, this debate circles around the respecting within conflicts. While I do respect the idea that cultural conflicts are important, it is also important to understand that during conflicts is not the time to look at the different cultural norms. What we are talking about is international human rights norms, which are only norms because they have been agreed upon, as my colleague stated, through conventions, through agreements. And it is often that during conflicts you get the worst, as we've made the worst abuses of human rights laws. And that is why it is fundamentally important that during these times we must respect international human rights law, because human rights law, if it does not take precedence over national autonomy, cannot function as made clear. It is also clear that nations have consented to these norms by agreeing to not just one or two, but often 4 or 5 different conventions, such as the Geneva Convention or the UN Declaration of Human Rights, and that their agreement in there suggests that they have a duty to uphold these. While respecting cultural context is important, conflict is not the time to do this, as evidence shows that conflict is in fact the time when the most fundamental rights that we have brought up are breached most. And that if we are to have a standard of international human rights, this must be applicable to everyone, and especially when considering the norms, because that is what's fundamentally most important, and that is what often protects people during conflicts, because they are left vulnerable or killed or have their basic liberties stripped from them. And that is why national autonomy cannot supersede international human rights, especially in this context. Thank you.
Thank you for your submission. You now can relax. You are no longer a degraded part of the match. You take a sip of water, a sip of bread, and my colleague will host the final part of the session.
Yes. So many thanks for this match. It was very, very good to see you starting the competition with such very good level already. Now we'll give the floor to each of you to ask for your impression on the topic, on the match itself, on the argumentation of the other team, because you were both researching on the same topic. And afterwards we'll talk a little bit about the possible connections between Manchester and Fiji. First of all, Miss Fatimatou Zahra Diallo, what did you think about the match, the argumentation? Did you already study this topic in the past?
Yes, so I really enjoyed listening to the opposing team's argument because initially, while researching this topic, we came up with a bunch of arguments for being in favor of the motion. And what the opposing team mentioned isn't something that I had thought about. And so it was interesting to see them frame the argument in such a way. I also learned a lot because I'm taking a public international law module at the moment, and this topic really served to improve my general knowledge on this topic, so I really enjoyed it.
Thank you very much. Mr. Varunesh Vikash Permal in Fiji, what did you think about this topic? the match itself, the argumentation? Did you already study this maybe in the past?
Oh, thank you very much. I enjoyed the debate. It was very interesting listening to perspectives from the University of Manchester. I actually love researching about the topic, given that it's a very complex, layered discussion, which can be argued from both sides. Especially when we were coming from the negative side, we had a lot of good points. You could say, because coming from a Pacific perspective, there are a lot of human rights issues being done here. However, yeah, it was a very interesting learning experience. So thank you to the University of Manchester.
Thank you very much. Mr. Atassi, so as well, same question, and as well, what do you think about the other arguments? Did you maybe come across some of them? I mean, the argument of the other team when you were researching?
It was interesting to see the approach the other team took to the question. I mean, we took, I think, a different approach, especially in the respect to the conflicts element. And it was interesting to see how they interpreted the motion different to us. So we didn't actually have the same arguments as them when preparing for their side. We had a number of different ones. So it was quite interesting to see the different approach. And I haven't studied this before, so it was I learned a lot from their kind of approach and their perspective that they brought into the debate.
Thank you very much. Vishalni Prakash, so what did you think about the match, the argumentation of the other team, and as well, if you already have seen this in your studies before, and yes, in general.
So from this competition, like, I got to learn a lot of researching, because this is like my first time actually learning about international law, like its nuances. I haven't done it yet. And especially from my opposing party, University of Manchester, I got to really like understand how they lay out their arguments, how they give stats. It's like this content is important, but the delivery is equally important. So at the same time, I got to actually learn from my opposing party on how to do the delivery, because this is like my first time experiencing this platform, and it's very exciting, but at the same time, that pressure but that excitement. So yeah, it's a great learning experience, I must say.
Thank you very much. We have as well Mr. Adalberto Dionisi. So what did you think in Manchester about this match against the team of the South Pacific?
Yes, it was very exciting. As Abdullah said, we had different thoughts for the questions from one of our fellow colleagues, and so we had some counter arguments prepared for what we thought they were going to say. They said something else, and so we ended up thinking, "Oh, what are we going to say to that?" So it was very exciting having to think on our feet and come up with something for that. Yes.
Okay, many thanks. And now for Kaya Nagma Lal. So what do you think about the match and the preparation, the argumentation of the other team?
Yep, so I haven't officially taken a human rights or international law course, but we've definitely had unofficial discussions on this topic. You know, coming in from a Pacific perspective, culture is very influential in shaping our legal systems and just generally how we perceive life. So it was interesting to take an official stance on this. In terms of debating here, I think this was an amazing platform to meet everyone and hear the alternative perspectives. It most definitely broadened my understanding on this topic, and I think everyone did very well today. So thank you, everyone.
Thank you. Many thanks to all of you. Now we enter the very last part of this session, which is a bit more of networking. It's a bit more, let's say, relaxed questions, because we try to connect the students between them, even if you have a 12 hours difference between Manchester and Suva. But still, yes, it's a good opportunity. For example, Miss Diallo, have you met anybody from Fiji in your studies or in your life before?
Never. This is the first time.
Okay. And what would you advise if, let's say, they come to Manchester to visit?
Oh, just make sure to have a big, nice jacket with you because it's always raining here. So, yeah, just cover up. It's always raining.
Okay, thank you very much. So yes, that's not a cliché. Indeed, it can rain a lot, like in the Netherlands, by the way. Varunesh, Vikash, Permal, what would you advise students from Manchester to visit or to do in Fiji? And as well, have you met or do you have any friends in Manchester eventually?
Unfortunately, I have never met anyone from Manchester, I follow Manchester United, so I don't think I don't know if that counts.
Okay.
And also, Fiji is awesome. It's beautiful. You will love the bula spas, the food. It'll be awesome if you come and visit here.
Okay. Thank you very much. Mr. Atassi, have you met anybody from Fiji before? As well, what do you know about Fiji?
I've not visited Fiji before. I don't know anyone from Fiji. I know beyond maybe the geographical location, I probably know nothing about Fiji. So very interesting to meet people from there. And the gentleman that said he would support Manchester United, I would like to address that I support the fierce rivals of Manchester City. So if I would advise him, as somebody who lives in Manchester, to support the better Manchester team.
Of course, many thanks. That's a good welcoming words for a visit eventually. And let's say on the other side in Fiji, Vishalni, Prakash, what would you advise to your friends in Manchester now to try to eat eventually? Are there anything particular from Fiji to try as in gastronomy?
Pardon, sir, I couldn't hear you. I'm having a bit connection.
Yes, what could they try in terms of...
I was not able to hear you. I'm just having a bit connection issues. So could you...
Yes, sure. So what do you think the first time they would arrive in Fiji from UK, they should try in terms of food, in terms of gastronomy in Fiji?
Oh, food. Everything about Fijian delicacy is a bliss, I must say. So, but best, I think, lovo. Lovo is really good. One must try that because the way it's made, because it has this smoky texture to it, but at the same time, it has that creaminess at the same time. So, lovo is best.
Okay, thank you very much. Now you will have the same question, Mr. Dionisi. I know that probably you don't have maybe the same opinion about Italian food than British food, but what do you think they should try when they come to Manchester, students from Fiji, in terms of food?
Yeah, I'm not too. I come from Italy, so I don't know much about the food scene in Manchester. I've had beans on toast, which is maybe a staple. It's not very good, but it makes for a quick meal. So you can try it at home. Honestly, don't have to come here for it.
Okay. Thank you very much. So what we want to emphasize indeed, keep contact because you never know in the future to be useful in your career to know some young jurists and lawyers in both countries. If you have a case, if you have so I would say in general in your career it will be good to keep contact. So don't hesitate to exchange, of course, contact details on LinkedIn or on other platforms. And this way, yes, it's just the first match. And of course, you'll meet more students through the competition from all around the world in your group first, and after in the next round, of course, during the next few months of this competition. So many thanks to all of you in UK, in Fiji. I have to mention that strangely, I've never been in Manchester, even if it's not far, from the Netherlands geographically. But I've been in Fiji once 4 years ago because I was making a stop between New Zealand and South Korea. So yes, both places are really interesting place for sports and for other reasons as well. So many thanks all of you. Wish you a good weekend. You will receive the results from the 3 judges who are watching or will be watching the match today or on Monday. And you will receive it on Tuesday or Wednesday, the results. So many thanks again. Have a good weekend over there. Many thanks, and we keep in touch, of course. Bye-bye.
Thank you, everyone. Well done today.
Well
Thank
done.
you.
Bye-bye.